Well, let me begin by introducing our two distinguished panelists. Dr. Fatou Bensouda is the prosecutor of the International Criminal Court, having assumed that office in 2012, the first woman to serve as ICC prosecutor. Dr. Bensouda was nominated and supported by the African Union as the sole African candidate for the position. Between 1987 and 2000, Dr. Bensouda served as Attorney General and Minister of Justice and Chief Legal Advisor to the President and Cabinet of the Republic of the Gambia. Her international career formally began at the UN International Criminal Tribunal for Rwanda, where she was trial attorney, senior legal advisor, and head of the legal advisory unit, after which she joined the ICC as deputy prosecutor. She is the recipient of numerous awards, including the distinguished ICJ International Jurists Award, the World Peace Through Law Award, the Peace Prize of the United Nations Association of Spain, and many others. In addition to receiving a number of honorary doctorates, Dr. Bensouda was listed by Time magazine as one of the 100 most influential people in the world, by the New African magazine as one of the most influential Africans, by Foreign Policy as one of the leading global thinkers, and as one of the 50 leading African women who advance the African continent. That's just the tip of the iceberg. Our other panelist, Ambassador David Scheffer, is the Mayer Brown Robert A. Hellman Professor of Law and Director of the Center for International Human Rights at Northwestern University School of Law in Chicago. He also serves as the UN Secretary General's Special Expert on UN assistance to the Cambodia Khmer Rouge trials. He was the first U.S. Ambassador at Large for war crimes, serving from 1997 to 2000, and was head of the delegation, the U.S. delegation, in UN talks that established the International Criminal Court. He authored the award-winning book, All the Missing Souls, A Personal History of the War Crimes Tribunals, and received the Berlin Prize in 2013. In addition to his very heavy schedule, Ambassador Scheffer chairs the American Bar Association's Working Group on Crimes Against Humanity, the purpose of which is to assist and encourage members of Congress in enacting crimes against humanity legislation in the United States. Now let's have a conversation. As I said at the outset, I have a number of questions, and I may not get to some of them because I do want to leave time at the end for participation by the audience with your questions. But let's move along as briskly as we can. And I'm going to address the first question to Dr. Bensouda. As you approach the halfway mark in your 9-year term as prosecutor of the International Criminal Court, you have spent much of your time developing and implementing important initiatives for the office. Please share with us some of those initiatives and give us insight into how the Office of the Prosecutor functions today. What changes have you prioritized to help the office fulfill its mandate under the Rome Statute?
Thank you for that question, Michael. And just to register that I'm very pleased to be here, to have this opportunity to interact, and always very pleased to see Ben. And hopefully we'll have a chance to exchange some more today and tomorrow. You're right, Michael. When I assumed office as prosecutor of the International Criminal Court, it was absolutely crucial for me to try and build on the cases that are already existing when I came, to build on those accomplishments, and to do some kind of a house cleaning, if you may, of what was already in existence, and build on the accomplishments as we go forward. So for me, having strategies, policies, looking at the best practices, these were very important issues for me, and see how I can actually make the office more efficient and more effective. Because this is important. The office of the prosecutor is the office that more or less is the engine of the court. We bring in the cases, we prosecute the cases, and the effectiveness and the efficiency of the office is crucially important for that. So one of the first places that I said I was going to concentrate on, I did concentrate on a couple of other issues, but one of the cases I said is absolutely important to lend some attention to was in the preliminary examination work of the office. As you know, the preliminary examination work of the office is one that spans, in this case, over many countries that currently we are looking at, including, I would say, outside of the African continent. This is not always very well known. But I said that I was going to look at the preliminary examinations. I was going to see how much I would be able to advance them, and then come to a conclusion, go to the next phase, whether it is to open investigations or whether it is to close it. But there must be attention placed in this area to be able to give clarity to people. Some of the preliminary examinations have been there for over 10 years now. And it is crucially important that we try to show that we are working on it, I'm paying attention to it. And by so doing, you can say that today, for instance, one of the areas I focused on, like Georgia, has moved from a preliminary examinations into an investigations, which I went back to the judges and I sought for authorization to be able to proceed, which was given. I'm currently investigating in Georgia. I've also been able to significantly advance the preliminary examination work on Afghanistan, as well as on Palestine, on Ukraine, and on other areas. So these are important areas. I mean, all of them are important, but some really, it was important that we tried to show that we are working on them and that we are advancing them. There's a lot of work that the office is going, and maybe let me take this opportunity to just encourage my staff and to thank them for the dedication and the commitment that they have shown throughout this period. But of course, a lot of work needs to be done. A lot of work is still being done, and to ensure that my office remains efficient and effective, I had initially talked about some of the strategies that I'm putting in place. Like there is the strategic plan of 2015 to 2018, in which I have made significant changes to how the office was approaching its work. And one of the areas that I just wanted to mention was, you will recall we used to have the strategy of focused investigations. One of the things I tried to do was to make an open-ended investigations, of course with a focus, but at least trying to target not only the highest responsible, most responsible at the initial stage, but also looking at the notorious perpetrators of these crimes that can actually lead us to the most responsible. This was a strategic shift that I made from the very word go. And again, one thing I tried to do was to ensure that before we approach the judicial process, that we are as trial ready as possible. That in fact, even once we're going to seek for arrest warrants or we are asking for confirmation of charges, we are also as trial ready as possible. This was another shift that the office has made, just to show that during the investigations phase, it is important that we focus on those areas as well. I could talk about more things that we've put in place, but these are just examples I wanted to highlight. Again, with respect to the code of conduct, I believe that an international prosecution's office has to have the highest standards of conduct in this work. And one thing I thought was crucially important was to have a code of conduct for staff. not just staff in the field, but the entire staff of the office, starting from myself to my deputy. I also ensured that there was training in the office, in the code of conduct, in which I also attended. I believe this is crucially important for us to also show our seriousness about the issues that we are dealing with, and also to show that we are committed to what we are dealing with. There are very, very serious issues, very grave crimes that have been committed, hundreds of thousands of victims who are also looking up to us. And I think that the office has really need to step up and show that we have that integrity, that we have that competence, that we have that experience to be able to deal with such serious crimes. So that is the code of conduct. Another area that I've been trying to give clarity in and prioritizing is there are certain things like sexual and gender-based crimes. This has been a priority for my office. This is something that I've lifted to be a strategic goal, in fact, in my office. And in 2014, I had a policy. I launched the policy paper on sexual and gender-based crimes, which was done after a lot of consultations with all stakeholders, with the states parties, with academia, with civil society that have been very supportive in that. I have had extensive consultations before that policy was launched in 2014 at the margins of the Assembly of States Parties. I immediately set my office to work on a policy on children. I'm picking these ones because I wanted to highlight the vulnerability of women and children. I think these are things we need to continue to highlight. And having the opportunity of being the prosecutor of the International Criminal Court, and given the Rome Statute, which provides me with an opportunity to really give the importance it deserves to these fields, I decided to concentrate on those as priority for my office. And the children's policy, which by the way also was launched just last year in November, was to show that we should be concerned about what happens to children during conflict. And here I'm not only talking about children who are forced to carry arms, but children who are affected by arms. And this was the angle that the policy took, again with a lot of consultations, and I got very useful information from everyone, experts. We did consultations with outside experts, as well as even with the staff of the office, and not necessarily only the staff of the Office of the Prosecutor, but the staff of the court were also able to have an opportunity to say something or write something, comments about the court. So these are policies, again, which I think are important right now. I have just launched, formed a working group to work on the policy on cultural property, buildings and monuments that are dedicated to culture, to religion, and to history. Right now, we are trying to do that. So these are the policies that I think that as an office, if we are able to, within our mandate, give clarity and also maybe encourage national jurisdictions to also look at the way in which the office is looking at these policies, it should be very, very useful. Talking about the core cases, last year, there were actually a lot of important developments that took place, or important achievements for the court. Last year was when we had the Jean-Pierre Bemba decision. Jean-Pierre Bemba, as you know, is a commander who was charged with offenses committed by his troops, particularly offenses relating to sexual and gender-based crimes, in which the court has convicted Mr. Jean-Pierre Bemba, firstly as a commander, not maybe in the field and committing the crimes himself, but the fact that he was a commander and that his troops, that he should have had that control over his troops who were in the field committing these crimes. Mr. Jean-Pierre Bemba had to get the conviction from the judges of the ICC. Last year we also had the conviction on Al-Mahdi. Al-Mahdi is the first person who was tried by the International Criminal Court for destroying buildings and monuments that are dedicated to religion and culture in Timbuktu. Mali is a case that was actually referred to the court by Mali itself. I remember it was maybe 2 months into my assumption of office. Mali was referred to the case, and we prioritized the fact that the destruction of these buildings is also very important, and the world should not forget that we have actually a duty and responsibility to prevent their occurrence, and where they do occur, to be able to bring charges against those who are said to be responsible for them and have that measure of accountability. So these are some of the achievements that also last year took place, coming back to what I said, that I had to build on the existing cases, but also develop new ones. Another one that maybe also was not well known is the case against, again, Jean-Pierre Bemba himself and 4 others, including his lawyer who was representing him in the main case, the trial lawyer, a member of parliament from Democratic Republic of Congo, and another friend, who set up themselves to interfere with the course of justice by interfering with witnesses, by coaching them, by paying them, and by asking them to come before the court and give false testimony in the main case. And this was an opportunity for me to highlight the fact that amongst the many challenges that the ICC faces, this challenge of witness interference and witness tampering is something that we needed to take action and to show that this could actually derail the integrity of the proceedings that we are holding before the ICC. So all of the 5 have been convicted, as you know, and the sentencing just took place about a couple of weeks ago, in which the ICC judges have sentenced all 5 of them, including Jean-Pierre Bemba, for these crimes. Maybe I will stop. I just tried to bring out the highlights of what I have been doing in the past couple of years. As you rightly said, in June I will be halfway through my, in fact I am already halfway. In June I will have a couple of years left in my mandate.
Well, I know, and a number of us in this room know, that there are many other things that you could add to your list. But that, I think, this gives all of us in the room an idea of what you've been doing since you took office. You referred to the preliminary examinations and investigations, and that brought to mind that 2 weeks ago, when I was in China at Peking University Law School teaching the course on international criminal law, I happened to, on the internet, which you can still access in China if you know how to do it, I read your 2016 year-end report on preliminary examinations and investigations, and I commend that to everyone in this room, because it's an up-to-date listing of the activities of the court. And I thought that the students would benefit from reading that, so I made it assigned reading, and they read that, as well as other things that we might touch on a little later on. But thank you for the answer, and there may be some questions afterwards from the audience. David, Ambassador Scheffer, I have a question for you. As I mentioned, you were the first ambassador at large for war crimes issues, and you have been representing the United States for many years, especially during the dramatic growth of the field of international criminal justice. And in many ways, you're probably the best placed person to be asked the question I'm about to ask. How do you analyze where the field of international criminal justice is today? And where do you see it going? What are the impacts and the potential of international criminal justice? And what does it need to do the work and to improve?
Well, thanks very much, Michael, and I just want to say how honored I am to be with the Madam Prosecutor again, and of course with Ben Ferenz in the audience as well. I have to say, I teach international criminal law at Northwestern. We try to do this every night, every class, to go through checklists like this, because there is so much going on in so many tribunals that to try to convey to law students in one semester a sufficient amount of fundamental information is always a challenge, because it's just knocking off one achievement and also setback after another in the courtroom. So I applaud the way you just did that, Madam Prosecutor, for the ICC over your term so far as prosecutor. Let me just say that there's no question that international criminal law is under attack in some ways, but the skepticism is out there. There are leaders who scorn it, who act against it, who do not comply with it. But at the same time, the institutions are remaining resilient. They stand. They continue. They continue to get their work done, even though it may not be the prominent headline that is drowned out by the skeptics. The skeptical leaders who are actually violating it will drown out the news. Meanwhile, justice churns along day after day, week after week in the tribunals. And I think we have to remember that these international criminal tribunals are not intended to change the world in all of its aspects of violence and confrontation. That's the business of politics. That's the business of our military experts, of our sociologists, of our therapists, quite frankly, is to make those kinds of changes so that violence, which Ben has fought for his entire life, so that we bring this violence to an end. The tribunals can stand as examples, as potential deterrents, as educational institutions for future generations who look back and say, yes, in my society, that tribunal had an impact, and I am absorbing that impact. I think in the last 25 years, what we can safely say, and I know I'll be challenged, but what we can safely say is that there is no longer a presumption of impunity. The presumption is dead. The question is, effectively, for those who continue to defy international law and international humanitarian law, the whole field, can we actually bring them to justice ultimately? That is the challenge. It's not sitting around saying, oh yes, impunity has some value in modern society. Anyone who sits at a table arguing that point of view should frankly be sidelined for purposes of morality and law at this point. But I think trying to bring individuals to justice is the business of the tribunals, and there has to be a certain level of patience for it, a certain level of continuous governmental support for it. But I think that once you can establish those lines of support, that we have to look at the tribunals not only as what are they doing for us today, because that's a very tough question. I mean, on any particular day, yes, their investigations are underway, the trials are underway, the judges are sitting trying to write their judgments. All of this is a multi-year project. Do not expect any instant results from any particular tribunal at all. But you must expect from them a historical result, a generational result, and hopefully a shift in the attitude to support this process. Take the long-term view, understand that these tribunals are not the answer to all of our problems, that you still have to make good policy decisions to stop fighting. The tribunals are not there to stop fighting. They're there to bring justice. If there's a supplemental benefit to stop some of the fighting through deterrence, great. But their purpose is to bring criminal justice to bear and to have that impression sort of invested in that society for generations to come.
Okay, thank you, David. The next subject I want the two of you to address has to do with state cooperation with atrocity crimes, investigations, and prosecutions. And let me set the table this way. In national criminal systems, investigators have access to crime scenes and evidence. Judicial orders are respected. police are ready and willing to enforce those orders. But as both of you are well aware, and many of them in this room are aware, the international criminal system is quite different. Dr. Bensouda, you primarily operate from the perspective of an international judicial entity, the ICC, requesting and greatly needing the assistance of states. And Ambassador Scheffer, you've been primarily on the government side, dealing with such requests. Tell us about state cooperation and assistance from your perspectives, respective perspectives, touching upon some of the challenges and successes and about how the current system could improve.
Michael, you talked about investigating at the national level. To really tell you the truth, that with hindsight, I wouldn't call it a piece of cake, but it's really very, very easy. And I'm saying that from the cooperation aspect, because at the national level, prosecutors, you have your police, you have detectives, they go, they investigate, they get the, and when you say arrest this individual, the individual is arrested and brought to trial. This is not the same thing at the international level, unfortunately. And there are several challenges with respect to our own investigations and able to get people who are investigated and are subject to arrest warrant being brought before the trial, before the tribunal, before the courts for prosecution to take place. It's a huge challenge, and I just need to refer to maybe a case like the Omar al-Bashir case to give you an example. But I will come back to that. At the international level, as you know, under the Rome Statute, we have a whole Chapter 9 which deals with cooperation. The way the court was set up was that the ICC is a judicial institution. It will investigate these atrocity crimes, war crimes, crimes against humanity, and genocide. It will identify individuals who are at least alleged to have committed these crimes and that they should be brought to account before the ICC. And in that particular case, the states who have created the court, as you said at the very beginning, the Rome Statute, ICC is a treaty-based institution. States have come together and convinced each other, or convince ourselves that we need to have a permanent independent institution that will be responsible for investigating and prosecuting these atrocity crimes wherever they occur and where we have jurisdiction and that particular state is not doing anything. That is basically the ICC. So cooperation is very, very important. ICC will do its judicial work, but the states undertake to support the ICC. They undertake to arrest individuals who are found on their territory and surrender him to the ICC or her. And they also undertake that when the judges of the ICC make rulings that affect something to do with states, that they will implement that. At the same time also, they undertake that as far as logistical issues are concerned, they will support the office of the prosecutor in trying to investigate these atrocity crimes and prosecuting them. Of course, the investigations will always be independent. No state is requested to investigate for the ICC. We have to do it ourselves. But the mere fact that we deploy to their territories, we will need their cooperation, logistical cooperation, to be able to do the investigations. So this is how the system is. This is how the system has been created for us to work with each other, each one doing their own part. And if one fails to do its part, for instance, if states fail to cooperate with the ICC, if states fail to arrest individuals and bring them before the ICC, the work of the court cannot go on. It will not be effective, it will not be efficient. And this has to be highlighted. With respect to individual state cooperation, I must say, and maybe I will take this opportunity to thank all those states that have been cooperating with the ICC in our work. And I want to particularly thank the African states. And I'm saying this because contrary to what has been in the media, what is always said that AU does not want to cooperate with the ICC, AU is AU. AU is not a state party to the Rome Statute. The African states are states parties to the Rome Statute. And since the work of the ICC started, and as you know, many of the cases have been referred to the ICC by African states, they have cooperated with the ICC. We have, I can say that if we ask for 90-something% of requests for assistance from states, almost 60 to 80 come back positive, and they assist the court. And I want to recognize that, because I don't want it to look like Africa has turned its back on the ICC. That is not the case. We are still making requests for assistance, and we are still calling on individual African states who are responding positively to the work of the ICC. I think recently what we have seen, or maybe I can address that later, because I just wanted to talk about these sensational headlines of all African states withdrawing from the ICC and things like that. I can address that later, but I just wanted to say that cooperation is critical to the work of the ICC. We just need to have that level of cooperation, and that cooperation should not just be in name. It has to be meaningful, and it has to be timely. We have had examples in which that level of cooperation, being meaningful and timely, has also hurt us in our cases. So it's critically important that ICC has that level of interaction, that level of cooperation, to be able to effectively carry out its work.
David, before you answer it, I'd like you to address this, Dr. Bensouda. Whenever I read that Omar al-Bashir has gone to yet another state party, and that state has not turned him over, has not arrested him, it grates greatly on me, let alone the members of the court. Do you want to address that? And is there anything that you would bring out to suggest that how to deal with that situation, the al-Bashir situation?
In my earlier remarks, I talked about this obligation that states have under the Rome Statute, under the treaty, to be able to arrest, for instance, individuals who are found on their territory and are wanted by the ICC. The example you've taken is perfect. It's the Omar al-Bashir case. The case came before the ICC. I think I need to mention this, not because of a referral from Sudan. Of course, Sudan is not a state party. But the UN Security Council made a resolution, 1593, and referred the situation to the ICC to investigate and prosecute the crimes that were taking place in Darfur since 2003 up to present. We need to remember that since 2003, that's a long number of years that we're talking about. And in that resolution, it recognized, of course, that there were non-state parties, but it also urged the non-state parties to assist the ICC in its investigations in that particular case. Not to talk of the states parties of the ICC, who already have the obligation under the Rome Statute. By being state parties, they have that obligation to arrest and surrender if al-Bashir comes to their territory. We have seen, however, over time, we've seen that Mr. al-Bashir, President al-Bashir, is traveling. The most recent one was to Jordan. Jordan is a state party, one of the few state parties that we have from that region, that has also received President al-Bashir without arresting. We have seen what happened in South Africa. There also, I think for me what was an important lesson to learn was that the domestic jurisdiction of South Africa was willing to take on their government about their responsibility and their obligation to arrest Mr. al-Bashir. We've seen what has happened in the meantime to the highest court in South Africa, saying that South Africa has not respected its constitutional obligations, because in the case of South Africa anyway, apart from being state parties, they are also domesticated, the Rome Statute. So the judges were saying that constitutionally it was wrong to let al-Bashir go. We've just had a hearing last week, I think on the 7th of April, in which these same issues the judges were listening to. Of course, South Africa was represented and had made its her submissions before the judges regarding this obligation that they have or don't have under the Rome Statute or international law to arrest Mr. al-Bashir. But these are things that over time have been happening. For now, up to the present, there are quite a number of state parties that have received President al-Bashir. Some have had reactions, of course, from the domestic system, like in Nigeria. I think Steve Lamoni mentioned that. It had local NGOs agitating also to have Mr. al-Bashir not be present there, and he left, I believe, before the meeting started, as well as in Chad, in the Democratic Republic of Congo also. So there are quite a few countries that are now saying the obligations that we have under the Rome Statute is different from, for instance, the obligation we have towards the African Union. That's one example, because the African Union came up with a resolution saying that AU should not agree to arrest Mr. al-Bashir, and this is a resolution that is signed by all African states. So there is tension. There is tension with regard to that, of states saying whether they want to respect what their obligations are under the treaty, or whether they want to respect some other treaty or some other resolution that they are part of. So it's creating difficulty. But for me, I believe we should, as much as possible, continue the dialogue and the engagement with the African states regarding that. It does not mean that I do not still believe that their treaty obligation under the Rome Statute to arrest and surrender trumps everything else. This is what I believe as prosecutor of the ICC, and this is the position that I have been trying to advance all the time.
Is there just one last thing for the benefit of on this subject, because it is such an important subject, the failure of states to cooperate and live up to their obligations under the Rome Statute. There are now 124 states parties, correct? Is there no mechanism in the governing papers of the Assembly of States Parties that authorizes the ASP to deal with the situation? Not in a punitive way, but in a way that would break this constant, it's now been 14 years.
Yeah, well, obviously...
And I'm not just talking about al-Bashir, I'm talking about any state that fails to live up to its obligations under the Rome Statute to cooperate.
I believe that given the events of last year, the states themselves are also engaging in more dialogue and more interaction with respect to issues like this, like Article 97, Article 98. These are things that, these are articles that the states parties themselves have decided to engage in. There was a very interactive dialogue last Assembly of States Parties, and I don't think that is the end of it. It is not, I don't think it is an easy issue to resolve. We have to be realistic and accept that, because really the obligations that arises under the Rome Statute is very clear. It's very clear with respect to how to deal with these persons that are found on your territory. At the same time, some of the states parties are saying that it's a problem for them, because it kind of creates a conflict in how they deal with these issues when it comes to also respecting other treaty obligations that they have. So the discussion is on. It's mainly a state party discussion. Of course, the office and the organs are asked for their views, but it's really mainly a state party discussion that is already underway.
Thank you, David. Sorry to delay, but I'm sure you're going to solve this problem for us.
Well, I just wanted to supplement what Madam Prosecutor was saying. Imagine how nonsensical it is to a negotiator. I was the negotiator in the group with the Rome Statute. How nonsensical it would be to draft an arrest obligation, also have Article 26, right, which is the official capacity article, that no one's official capacity immunizes you from indictment before the court. And you have state parties that are party to the treaty, and then somehow have we worked something into the statute which says that contradicts all of that? Now people would say, but what about Article 98.1? I won't go into the long argument now because we could go into it. But the point being that Article 98.1 is not the safety valve for state parties to avoid their obligations of arrest and also to honor Article 26. It's simply, it's a nonsensical negotiating position to have negotiated the document in that manner. It doesn't make sense. It avoids logic. And so we weren't sitting there saying, but if you're a head of state, you never have to be arrested. That's, forget the indictments and everything else. You are immune if you're a head of state. We never negotiated that. We never discussed the statute in that character. So it's a nonsensical position from that perspective. I would also say that given that it's a Chapter 7 referral by the Security Council, that even strengthens the point of the logic of the statute. Where I think we have some problems is the lack of political will by the Security Council to truly follow through with their own Chapter 7 referred matter, where yes, a head of state has been indicted pursuant to your Chapter 7 referral, so please come back on deck and assist us to enforce what you have asked us to do, and we have done it. Now, all back in your court. Assist us with this matter in terms of the ultimate arrest of President al-Bashir. Michael, I know you wanted to get on to some other questions.
Yes, David. There's been mention in the last panel discussion, as well as here indirectly, to the Africa-ICC relationship. And probably in most, if not every, public event that you participate in, Dr. Bensouda, you're asked about that subject. But let's look at this issue from a fresh perspective, if you will. There are three areas that perhaps the two of you can address yourselves to. But first of all, what does the public need to know about this relationship and how it went off track? Secondly, what has your office done to improve the relationship or deal with the relations? And thirdly, what are some of the suggested changes that have been made that go too far?
In fact, you said that in most of the public engagements that I have, I get asked about this question of the ICC, Africa relations, the African bias, in various forms, but it's just the ICC Africa relations that I get asked about, and I can tell you that it's in all of them. It's not some, it's all. In all of the public engagements that I have, that is one question that always comes up. And for me, it provides an opportunity to describe, as you said, what is known and what is not known. Because there are, in all this mix, there's a lot of perceptions that unfortunately is very difficult to deal with, but they're using non-facts to actually support that perception that ICC is biased against Africa, that ICC is a neo-colonialist court that has been set up to target Africans. All of that is untrue. All of that is not true. One, it's not backed by the relevant facts. And fortunately, I'm sitting with people like David Scheffer, people like Ben, people like John, who are here, who were very much active when the Rome Statute was being negotiated. and who know the history of how this important court came into existence. Africa played a role. Africa played a big role. Africa was part of those states that were in the negotiations for the Rome Statute. Towards establishing the court, Africa played a big role in ensuring that the final ratifications that would get us to that number for the court to be established, Africa played a role. Again, we have to remember that Senegal, an African country, was the first ever in the whole world to sign and ratify the Rome Statute. Senegal, we cannot ignore that. I think this is symbolically very, very important, and also delivering a very important message. An African state being the first country ever to ratify the Rome Statute. And then followed other countries as well around the globe, but more and more African countries, to the extent that today 34 out of the 54 African states are part of the ICC. They've signed and ratified. I think this is significant, and this is something that we cannot just discount like that. It is sending a good message. It is sending an important message that Africa is also ready to respect international criminal justice. It is also ready to make use of this international criminal court that they are part of. So for me, this is significant. Again, I come to the work of the ICC, and starting when it did. The first referrals that the ICC received was also from an African state, followed by other African states. Today, we have from Uganda to DRC to Central African Republic to Mali to Cote d'Ivoire, all these referred their situations to the ICC, and most recently to Gabon. Just in November, I think, of 2016, Gabon referred their situation to the ICC, and this was after all the distraction that was going on. Countries are withdrawing, we don't want the ICC, it's neocolonial. Another African state, making it the 7th African state to bring their situation before the ICC. I think this means a lot. And I always say, I may be wrong, but I do think that in this, so far as what we've seen from the establishment of the ICC to now, I believe Africa is also showing leadership in international criminal justice, and we should not just discount it. Of course, there will be those who do not want the court to succeed. There will be the critics, there will be the detractors of the court who will want the court to fail because of their own self-interest, their own self-preservation. So these attacks that you have against the court, just for a moment, sit back and see where they are coming from. In the first instance, it's not justified because it is not backed by the relevant facts. And in the second instance, you will see that it's actually not the victims who are making these accusations against the court. It is the alleged perpetrators. The victims would want the ICC to intervene, because if you look at all the situations that we have currently, not in any one of them is any other government or judicial institution that is giving justice. None. In all the situations, and you can take a look. So the victims do welcome the fact that the ICC is intervening in these instances, and I always say, in as much as the perpetrators are Africans, the victims are also Africans, and they would want the intervention of the ICC. So this picture, Michael, that is created, that ICC is targeting Africa, is going after Africans, is not justified. There is a very strong machinery, propaganda machinery against the court that has been created, and it's doing its work, of course, in the interest of those who have set it up. But the reality, the hard reality is that the ICC is in Africa, first because it was called, and they can't do so because that is what the Rome Statute says. They can't do so, was called by states to come in. And secondly, the ICC has been working with and working for the victims in Africa in the cases that are in Africa. They completely discount and they completely forget that we are not only working in Africa. We also have cases outside of Africa. We have situations that are under preliminary examinations that are outside of Africa, where in any of them, if all the criteria, the legal criteria is met, in any of them, I will not hesitate to open investigations, and I will do so without fear or favor. So this has also to be clear, that apart from what we are working at in Africa, we are also working on other cases that are outside of Africa, which we have in fact been able to significantly advance them.
David, you want to comment?
Yes, just to supplement again what the Madam Prosecutor has said, in addition to Africa's concerns about the agenda of the court that she has spoken to, it is perfectly possible under the Rome Statute for African states parties, 34 of them, they could, as a state party, refer any non-African situation to the court under Article 13 of the Rome Statute. They have never done so. They could have referred Georgia a long time ago. I mean, I wouldn't even start to name the countries they could be referring outside of Africa, but they could do so, who are states parties, but who could be investigated for certain alleged atrocities. So they have the power to actually broaden the agenda of the court enormously outside of Africa, but they have never chosen to use that power. Secondly, the African bloc at the United Nations is a powerful bloc, just as it was in the Rome negotiations. That powerful bloc could be brought to bear on the Security Council, for the Security Council to actually bring North Korea to the attention of the International Criminal Court, quite frankly. In other words, China has a lot of investments in Africa. Bring some pressure to bear and get a vote. I mean, China can abstain. Thank you for your abstention. Russia could abstain. Thank you. But let's bring North Korea to the International Criminal Court. Africa could be the leading edge of that. And quite frankly, Madam Prosecutor, if you got North Korea and crimes against humanity that have been going on for decades, well, certainly since July 1st, 2002, in North Korea, you would have a lot of work to do, and you'd have a lot of additional leverage to seek more funding for that work, particularly from the Security Council and the United Nations.
Apropos of what you just said, David, and picking up on what Madam Prosecutor was saying, that any states parties can bring referral. I noticed in the 2016 year-end report, your report about preliminary examinations and investigations, that you're looking into Russia's actions with the Crimea and Ukraine with respect to possible war crimes and crimes against humanity. Can you tell us who referred that situation to you, to the Office of the Prosecutor?
That situation was referred by Ukraine itself. They actually made a declaration and accepted the jurisdiction of the court, which one can do if you are not a state party to the Rome Statute and you would want the intervention of the Rome Statute. You can make a declaration under Article 12.3 and accept the jurisdiction of the ICC. And this is what Ukraine did on 2 occasions, actually. For the same situation, but on 2 occasions they have accepted jurisdiction of the ICC. And my office is working at the moment. It is under preliminary examinations. We are collecting information, and we are looking at the conduct of all the parties that are involved in that situation. Talking about Article 12.3 declarations, again, as you know, it was put there. It was negotiated because we do know that there will be situations where maybe these atrocity crimes are committed and that particular state is not a party to the Rome Statute. So under Article 12.3, you can have that opportunity to accept ICC's jurisdiction even though you are a state party, and for ICC to work. If you recall, in the situation in Cote d'Ivoire, Cote d'Ivoire was not a state party when events were taking place, and they decided first under Mr. Bagbo, I remember some time ago, and also under President Ouattara, to accept ICC's jurisdiction. This is actually what started our work in Cote d'Ivoire, but soon after, Cote d'Ivoire decided to ratify the Rome Statute and became part of the ICC. But that opportunity under Article 12.3 is there for non-state parties.
David, I'm going to toss you a softball question. Assume that the White House calls you for advice regarding policy to address the current situations in Syria, Afghanistan, and Palestine. What do you think U.S. policy should be with respect to the atrocity crimes committed in those countries, and what are your reasons?
I don't think they're going to call me. I would pick up the phone, though, if they did. No, you know, this is such an interesting question because as so many in this room, we've lived for 6 years with this question being posed to us on Syria. And I was just thinking, you know, wouldn't it have been interesting if I had recorded 6 years of answers to this question and seen how my answers had progressed regarding the circumstances on the ground, the situation militarily, the death count, because I was answering this question 6 years ago. So how do I answer it today? Well, quite frankly, on the issue of accountability for Syria, we lost our chance in May 2014 for a Security Council referral. We can probably assume Russia will forever block that as a possibility for referral to the ICC. But 3 years ago, I published an article that you can easily Google in the Los Angeles Times, where I set forth a proposal for how to create a hybrid tribunal for Syria that would involve a treaty between the UN General Assembly, where I think we could get a majority vote in the General Assembly, forget Russia and China. And that treaty would be entered into with some regional actors, Turkey, Lebanon, Jordan, perhaps bringing in 1 or 2 Europeans, perhaps even the United States, if it were willing to go this direction. I think that there might be even some chance for that, whereby you have a group of states that have entered into a treaty with the United Nations to set up a hybrid tribunal with, and here's the kicker, just what we have in the Special Tribunal for Lebanon, which is in absentia jurisdiction. This will be tough for us common law lawyers to swallow, but nonetheless, we know that there's a tough chance getting al-Assad into the courtroom as well as his generals. Perhaps we can embrace what is accepted in the region, which is in absentia jurisdiction, Lebanon has it, and allow that tribunal to at least bring all of this investigative work to bear, which we know that there's a tremendous amount of investigative work taking place with respect to Syria in many different ways. There's now a General Assembly mechanism that is focused on this, bringing the evidence together, preserving it, chain of custody, etc. Bring that all to bear for that particular tribunal. And of course, if you can get custody, go for it, get custody and prosecute the individual, but at least have an option for in absentia prosecution of some character, and you can proceed on that basis. Jurisdictionally, I would argue that Turkey, Lebanon, Jordan, you bet they have jurisdiction. They've been flooded with refugees out of this conflict for 6 years, and as far as I'm concerned, bingo, that's jurisdiction. And so, because those refugees are there because of the consequence of the criminal activity on Syrian territory, and the statute of that tribunal can so recognize that jurisdiction, and the General Assembly can buy into it with a vote for a treaty. And then, of course, you look at how to fund it, etc. Those are always big questions. But I do think there's a way to get at Syria. As far as Afghanistan and Palestine, I think we have to recognize that the ICC, through the Madam Prosecutor's Office, actually is focused on certain aspects of Afghanistan, certain aspects of Pakistan, so I wouldn't suggest treading on that territory. I would just say I think the prospects for some kind of hybrid tribunal for those 2 jurisdictions is much slimmer, and that we would have to look, frankly, at building up the domestic court system over 10 to 20 years with that sort of ex post facto jurisdiction that would allow some of these atrocity crimes ultimately to meet domestic justice. Meanwhile, the ICC is seized with some measure of inquiry into those atrocity crimes. As far as militarily what to do in Syria, that's another story.
Okay. Madam Prosecutor, do you want to comment generally on the subject of Palestine and Afghanistan and clarifying the ICC's jurisdiction regarding Syria? Yes or no? You don't have to.
Yes, I can say a few words. With respect to Syria, let me start there, and also I can even say Iraq. Syria is not a state party to the Rome Statute, neither is Iraq. And in the absence of an Article 12.3 declaration accepting ICC's jurisdiction, I see that as unlikely. And also in the absence of a UN Security Council referral of the situation to the ICC is just the case that ICC does not have jurisdiction in either Syria or in Iraq. What I have done a few years back, I think it's 3 years since when the troubles started, and this issue of foreign fighters were more and more being talked about in both Syria and in Iraq. I immediately set my office to try and find out more information with respect to these foreign fighters, because the initial information we got was that there were nationals of states parties who were involved, who were amongst the ranks of ISIS and who were committing crimes. So I, of course, just for a way of looking at how the court, the ICC can contribute, I decided to ask for more information and to get my office to gather more information with respect to those nationals of states parties, whom I think we know today that there are about 34 states party nationals who were involved in the fight in Syria, ISIS, amongst the ranks of ISIS. And I did that because, as you know, ICC's jurisdiction is not only on the territory of states parties when these crimes are committed, but it's also over the nationals of states parties. And this is why I was saying that we need to have more information on those so-called foreign fighters who are found amongst the ranks of ISIS. And since then, I must say my office has also been not only collecting, trying to get information, more information on that, but also trying to engage with states whose nationals are alleged to be amongst the ranks of, and asking them for what they are doing, and also asking them for more information, looking for a way to at least even collaborate in trying to get, see what can be done about these foreign fighters that are both in Iraq and in Syria. There are, however, some challenges that we would face with respect to that. Firstly, if you look at the issue of going after the most responsible for the crimes, what, in accordance with the policy of the Office of the Prosecutor, what we have seen so far, or what we know, is that ISIS is both a military and a political organization. And we have seen that for those most responsible are mainly coming from either Syria or Iraq, which brings us back to the position that they are non-state party nationals. The state party nationals that we find are usually the foot soldiers, or those people who really are not the policymakers or the ones who are planning but are just involved in the fight. So it's a little bit difficult to be able to go after them because of the level of responsibility that they have in that, amongst the ranks of ISIS. But we are gathering more information. There was a time I know where we know a national of a state party who was really high amongst the ranks of ISIS, but unfortunately we got information that he had been killed. So these are the kind of things that we have been looking at to see how the ICC can contribute to what is happening in in Syria and also in Iraq. But given, as I said, the fact that they are not state parties is a huge challenge and a huge block for us to be able to exercise jurisdiction there.
Okay.
You talked about Afghanistan. You talked about Palestine. Afghanistan is under preliminary examination for a long time now, I must say. In the past year or so, my office had put a lot of resources and a lot of attention in trying to progress the file. And as I said in my activities report, it has significantly advanced. In fact, maybe I'll get the question, but I know that in my report I had said that a decision on Afghanistan is imminent. So many people have been asking this imminent, how soon is the imminence going to be? But when we mentioned that in the activities report, we had more engagement from parties that we are looking at, conduct of parties that we are looking at coming to the office and then engaging the office and providing more information, and which I legally under the Rome Statute, I'm bound to look at that information. So in fact, that is what my office is doing currently. So maybe that imminence has a little different meaning because of that. And with Palestine also, it's the same situation. We are conducting the preliminary examinations in Palestine. You will recall that Palestine joined the ICC in 2015, and they had also made a declaration in 2015, January, accepting ICC jurisdiction. So we are currently looking at the information. I must say that we keep getting information. So a lot of information, which again, I have the duty and the responsibility to continue to analyze and then to come to a decision sooner or later, but I can tell you that work is in progress.
Oh, may I just add one additional point on Syria? It is theoretically possible, but I would also argue that you asked if the White House called me. Well, I would say, okay, White House, here's how you can really use your political capital in real time with this administration, which is there could be a referral. We talked about this a little bit in the other panel. There could be a referral of ISIS to the Security Council, by the Security Council to the International Criminal Court. ISIS in all of its forms of violence in many, many different countries. And that the prosecutor is authorized, obviously within the subject matter jurisdiction of the court, to examine ISIS in terms of certain types of crimes. That would include, obviously, jurisdiction in Iraq and Syria by virtue of the Security Council. Obviously, investigations would be extremely difficult just because of the dynamics of ISIS. I think the problem is that Russia, while you could imagine a political deal between the United States and Russia to simply go right after ISIS, because they have politically said that that is their object, that is their target. Even in Syrian military operations, theoretically, they're supposed to be cooperating to go after ISIS, theoretically. The point is that's a point of good political discussion. The concern I have, of course, is that Russia might say anything regarding Syria we will say no to. We don't care if it's ISIS or Assad, or it would bleed over into the other areas that we don't want the court to look into. But the point is, you could theoretically isolate that referral just to ISIS. It would be controversial, I think, with some of our scholars about the Rome Statute, because they would say if you're on certain territory, then everyone on that territory should be subject to scrutiny for crimes on that particular territory, regardless of the party. But I would also say, in counter-argument, yes, but that's one of the values of the Security Councils, that sometimes they can step in and give the court an opportunity it otherwise would not have, and that is an important opportunity. It is critical, and ISIS is a critical priority on the international agenda, as of course Assad is.
Okay, we're going to open it up to questions from the audience, but I want to ask one final question to which you can give just the briefest of answers. And the reason for my asking this is that in the audience, people will be asked what argument can be made to our own government leaders and our own fellow citizens about why people in our own country should be looked at for violations. And let me set it up this way. I think what John Bellinger said in the last program makes a lot of sense. It's how you ask the question as to whether you get support or not for the premise that you're trying to investigate. I think it can safely be said that if the question is put to anyone in the U.S. or in the world, do you favor sanctioning people who commit atrocity crimes, you're going to get an answer, yes, of course, we can't tolerate this. But when it comes to your own backyard, people then will say, no, I don't think we should do that. So how can we persuade our governments, our government, other governments, that it's in their interest, self-interest, really, to pursue criminal accountability for atrocities committed by their own people?
Criminal justice within our own domestic sphere, as well as increasingly extraterritoriality in a whole range of different fields of anti-terrorism, money laundering, drug trafficking, etc. There is really no, there's nothing that should inhibit us from embracing the concept of holding our own accountable. And I say that for two reasons. One, under the Rome Statute, of course, complementarity invites states to simply move in that direction and do it themselves without engaging the ICC, to essentially tell the ICC, back off, we are handling this. Why? Because with the United States of America, we actually believe in this as a rule of law matter. So we are investigating, and we will hold our people accountable, which sometimes may mean at the end of an investigation that there's no merit to pursuing prosecution. That's perfectly acceptable to the ICC, as long as you make your case rational. What I do think we have to do in this country in order to make that argument as strong as possible and with confidence, and quite frankly, as I say, don't be intimidated by international criminal justice. Embrace it within your own society, because that is America, is to embrace it within our own society. And that's why the ABA has had this working group on crimes against humanity for 2 years now to actually fill that gap, or frankly void, in Title 18 of the U.S. Code, so that we have the full range of crimes against humanity with the chapeau requirement in our code. That way we can always say to the ICC, oh, are you coming after us for crimes against humanity? Well, guess what? We've got the basis under our own federal law to do this, and we are doing it. So please back off. Well, we'll keep talking to you, of course, but please back off, and we'll investigate this. I mean, that's what other countries do. And so we need to fill that, and that's why, with the support of the ABA, we've been able to press that forward. I mean, Kip Hale has been a champion of this process with me, for 2 years. He's now in Europe, still championing it. And of course, he champions this project as well. And I think that's one way we in the United States can, with confidence, much greater confidence, embrace the ICC if we simply put our own house in order on these important issues.
I'll also try to be brief by firstly just saying that in fact most of what David is saying, in fact all of what you're saying, I do agree with it. I believe that one of humanity's proudest moments was the creation of the International Criminal Court. I truly believe that, because the international community is saying we will no longer tolerate these atrocity crimes. It cannot happen. Those who commit them must be brought to account. And we are all committed to doing that. And again, we need to remember that, remind ourselves is one of the things that the ICC is meant to do is to continue to encourage domestic jurisdictions to take up this responsibility of investigating and prosecuting these atrocity crimes. The ICC was not created to replace domestic jurisdiction. This has to be clear. It was created to complement domestic jurisdiction, and where that domestic jurisdiction is not able to act because of lack of political will or lack of capacity, then you are part of an institution that can step in to investigate and prosecute. I think this is a good thing. It's a good thing that has happened. And states who are not yet part of the ICC should not shy away from joining the ICC because they think that this is a jurisdiction that is imposed on the state. It is not. It is a jurisdiction that has come in to first encourage you to do it by yourself without looking at the ICC. As you say, when they are doing it, you can simply tell the ICC, you know, we're doing it. Because the ICC, when these crimes happen on the territory of a state party, and we see that the state is taking steps to address it by investigating and prosecuting these crimes, the ICC takes a back seat.